Hello and welcome to Friday Live. I'm your host, Strata lawyer Amanda Farmer. We're going out live this Friday to the Your Strata Property Facebook page. If you're joining us from LinkedIn, special hello to you. We're live there as well. We're also live over on our YouTube channel. Welcome, welcome. It is Friday afternoon. We've all had a big week in Strata. This is our time to get together, to chat about some Strata issues, to wind down and get ready for next week's challenges. That's generally how I see the weekend. I hope you have all had a fabulous week. As some of you know, if you tuned in last Friday to our Ask Amanda Now session, I have been traveling, took the school holidays off the last couple of weeks. I am now, as you can see, back in my home studio or home office. It doubles as we've had a day of travel, but it is great to be back and to be here chatting with you about a couple of very interesting, I'm going to say, interesting, and as I said in my email today, increasingly important topics. We are going to get into our main event for today shortly. Just had some tech issues, as we do after we've been away for a little while and come screaming back into a Friday Live. So it's just organizing in the back end here what we need to be able to move along smoothly for today. Yes, we are going to be here for a longer session today. We may run till around about 5 o'clock. Most of that is going to be focused on the single topic, I'll say, that I popped into my email today because I said to a friend, a colleague, I'm going to let you know his name shortly on email just a couple of hours ago. This is a great topic. We're going to cover this today in Friday Live. That was a couple of hours ago. I then started to get my head stuck into this topic and went, wow, it's a big topic as well. And there is lots to cover. So I've decided that we will focus our next nearly hour on that topic. Already, David Glover is coming in saying, hi, Amanda. Hey, David. Wonderful that you're able to join us. Hello to Sean, giving me a glass of wine. There's been a few glasses of wine over the last couple of weeks. Holidays, catching up with friends, catching up with family. I think there's going to be less of that over the next few days, Sean. Wendy saying hello. Hey, Wendy. Hey, Denise. I think you're joining us there from YouTube. Great to see that you are here. If you're coming in and you want to say hi, whether you are live, whether you are catching the replay, I always like to see your hellos. If it is your first time live watcher, feel free to drop in and say hi. If you don't want to say hi, no problem. But all types are welcome. Those who just like to watch and not comment, not a problem. I'm glad that you are here. Karima's here saying, hey, Amanda, glad to be back. It's been a while. Lovely to have you back. Kareem, no doubt you have been busy. And hey, Sean, TGIF, indeed. So our agenda for today, I let you know if you're on our email list what we're going to be talking about, recording the goings on, I've said, of your Strata community, whether that is recording by video or recording by audio or maybe both, is a bit of a controversial issue. And it has been for some time. This question of, can I legally record Strata meetings? Is it okay if I secretly record Strata meetings? It's one that I've been asked since the earliest days of my career as a Strata lawyer, but these questions are becoming increasingly common. And I think that's for a few reasons. We have these devices that we can very easily press that button and record what's happening. We can do that without other people necessarily knowing that we're doing that. We're very used to doing that in our own environment, making our own voice notes. If you're anything like me, you do that quite frequently. We are also, since the pandemic, very used to online meetings and recordings of those online meetings. If you attend my webinars, I get hundreds of questions before a webinar, all generally the same thing. Amanda, is this going to be recorded? Are we going to get the replay of this? We're very used to logging in to an online platform, whether that's Zoom or a Teams or some other webinar platform, and expecting that it will be recorded. So as we're having more of our strata meetings online, whether that's committee meetings, general meetings, this question of, is this being recorded? Can this be recorded? Is this being recorded? And no, I don't want this to be recorded, are definitely coming up. And our strata communities are getting more complex. Our owners, as our strata managers will tell me, are getting more demanding, perhaps have higher or greater or more serious or just more expectations of what it is that a strata manager delivers. So having the ability to record meetings, both from the strata manager perspective and from the owner perspective, that's becoming an increasingly important question and a desire in some buildings to be able to have that ability, to have that functionality. So a question that has certainly been raised previously, one that I have attempted to answer previously, and I've said in my email today, I'm not sure that I've been giving the right answer to this question. I think it deserves a deeper dive, and that's definitely what we're going to be doing here today. Kevin is here saying, looking forward to the session today, Amanda. Hey, Kevin, thanks for being here. Hey, Sean. Sean and Sean M. I've already said hello to you. Say hello to each other. Love you guys. Shana is here saying happy Friday. Hey, Shana, how you doing? Okay, so we're going to get into that topic and spend most of our time there today. But first, the pod for this week, podcast episode number 425, Removing the Emotion from Strata Investment. I thought this was a good time of year to put this chat out there on the podcast. It is spring still. Traditionally, the time of year that is the busiest for real estate transactions. Some of you may be in the market. Some of you may have recently purchased. You might be looking for an investment or another investment, and Strata may be on the list for you. With the help of my guest this week, Aileen Jin, who is a buyer's agent, I'm sharing my tips for strata property purchases, what you should be a little bit cautious of and on the lookout for, and how you can find value, even though we are in an environment, most of us, where property prices are ever increasing. So a quick summary of the tips that I do give in that chat, and I recommend you go over and have a listen. We've got the link here for you that's going into the comments. You've heard me say it before. I say it in the podcast chat. It's getting a little bit trite, at least to my ears. Do your due diligence, and please do that before you sign the contract. Find out as much as you can about the building that you're buying into. And in the chat, I give you some tips as to how you might go about doing that. I also share how you might be able to seek out a strata property with some unique potential to add value. And I give you a couple of examples where I have personally been able to do that in the past, by chance in one example, by experience in another example. And those who are listening to the podcast, who are here tuning in on Friday Live, you have the knowledge. You have, many of you, through me and through others, the experience and access to the expertise to be able to make excellent purchasing decisions when you're buying into strata, not just to buy into more functional, hopefully more peaceful, more stable, more financially viable communities, but also to buy into buildings where others might think this is in the too hard basket. I don't really want to take this on. That might be an opportunity for you to get a great deal, and with your knowledge and with your support from this community, to be able to be investing quite profitably in the long term in strata. And I also talk about why you might not want to be looking in your own backyard when you are making a strata purchasing decision. I have seen plenty of owners, investors who purchase another unit in the same building. Maybe a great decision if you're confident that that building is on the right track, can come back to bite you if the building is not on the right track and you end up with two units having that obligation to contribute to that hefty strata levy or that strata loan. Have a listen to podcast episode number 425. You'll hear Aileen's tips in there as well from her experience as a buyer's agent. That link here for you in the chat. More of you coming in. Kieran saying, sorry, I'm late. That's okay, Kieran. You are welcome. The only person who is not allowed to be late is me. I try not to be late. George saying, hi. Hey, George. How you doing? All right. So lots of eyeballs here for our topic today. Thought this one might be a popular one for you. And this is hopefully going to be a great resource for you, for others, for me to refer back to when this question is asked in future. What's the question? Is it okay? Is it legal to record my Strata meetings or to secretly record my Strata meetings? This is a conversation that was recently started again in our member Q&A forum. I posted some of my thoughts in response to a member asking this question. And my comments were followed up by some very insightful, I have to say, comments sent to my inbox, backed up by some very solid research. That email came to me from David Glover. And I know David is here. I'm glad he could join us. I do have his permission to use his name. Thank you, David, for looking into this topic and challenging me, I think, with some of his research, asking some further questions and suggesting that this is such an important topic that comes up a lot. It's worth doing a podcast, a live chat, providing some resources to both managers and owners who are wondering about the legalities around this recording of meetings, recording of conversations in Strata. So thank you, David, for your prompt and for your notes. I did speak about this very question in some detail many years ago now when I go back and dig through past podcast episode number 20. 20. I think it was 2016, our first year out in the podcast. If you're going back to listen to that one, I'm not going back to listen to it. If you're going back to listen to it, things might have been a little different back then. Can you legally record a Strata meeting is the title to that podcast episode. If you have a particular interest in this topic and you want to hear again, reinforce, hear differently some of the things that I am going to say again today, then it is absolutely still relevant, that podcast episode. Link here for you to podcast episode number 20 and worth a listen. Today, I am specifically going to be talking about the audio recordings of conversations, communications perhaps, that happen in a Strata context. Whether that is actually in meetings, Strata committee meetings, general meetings, whether they're AGMs or otherwise general meetings, or even, and this is the scenario that came up in our member forum, a conversation that is happening perhaps on your own property between you and a contractor that the Owners Corporation has sent in to have a look at whether we need to or how we might deal with a repair to the common property. Perhaps there's a few contractors on the property. The member who was asking this question most recently in our forum was saying there's a couple of contractors coming. I don't have faith. I don't believe that they are going to be doing the right thing, that they are going to accurately relay back to the committee what their findings are. I'm concerned about what their conduct might be on my property. I'd like to record them. I know I won't get permission to do that. Amanda, can I record them when they are on my property? So those are the kinds of situations that I'm planning to address today. So not just limited to meetings, but other conversations that might be happening in that Strata context. I am going to be referring to New South Wales legislation, the Surveillance Devices Act 2017 in New South Wales. Our legislation across the country is not exactly uniform in this area, but I have to say from the few other jurisdictions I've had a look at, the relevant Surveillance Devices Acts or Listening Devices Acts are very similar across all of our jurisdictions. So absolutely do check the law in your particular state, but I think you will find that it will be very similar to what I'm sharing on behalf of New South Wales here today. More comments coming in. Sean saying, I've always said no So I'm interested to hear if it's otherwise. Yes. Nathan is saying same. There was a meeting I knew someone who was going to go to. And Colin Grace, another Strata lawyer, said to say pre-meeting, no recording permitted. So I'm very interested in this. Yeah, this might come up. Nathan. Sean saying, I've always said it would need to be agreed to by all participants. Debbie saying Queensland laws are different to New South Wales. Thanks for pointing that out, Debbie. I'd love to know if you want to drop a link into the comments to the relevant legislation that's in New South Wales. And if anything that I'm saying here in the New South Wales context jumps out to you as, oh, that's different in Queensland. I know you're often on top of things, so feel free to pop that in. This is a great place to be sharing our knowledge and our experience. All right, so I'm going to start, as I said, with the Surveillance Devices Act, New South Wales. I'm specifically going to share with you my other screen where I have our relevant starting point here. I'll just do that in a way that's going to be, I think, most helpful. All right, I'm using OSLI, Surveillance Devices Act 2007. It is in New South Wales. And I'm going to go straight over to Section 7, which gives us the relevant offence, if you like. What is it that is illegal when we are talking about the installation, use, and maintenance of listening devices? So specifically talking about listening devices here today. Section 7 in our New South Wales Surveillance Devices Act says a person must not knowingly install, use, or cause to be used or maintain a listening device to overhear, record, monitor, or listen to a private conversation to which the person is not a party, or to record a private conversation to which the person is the party. So that's Section 7, subsection 1. We call that the offence. That is the criminal act. If you do that, then you are committing an offence under the Surveillance Devices Act, and you subject yourself to a penalty or possibly 5 years imprisonment. So in the case of a corporation, 500 penalty units is $50,000. 100 penalty units if you're an individual, that's $10,000. That's the potential fine that you're exposed to if you commit this offence, or 5 years imprisonment. And I know from David Glover's very good research that he popped into my inbox, he mentioned to me that at least in New South Wales, he was only able to come across one case where somebody, I think, David, you'll correct me, this is from memory, was ultimately sentenced to a prison term, and I think may have had to pay a fine as well. But that was a very serious case of stalking, a person who was stalking a number of, I think, ex-partners. Other than that, we're not sure that there have been too many reported cases where someone who has breached this section or committed this offence has been subject to this penalty. I'm immediately going to go down to an exception to the offence. It's in subsection 3 in Section 7 to the Surveillance Devices Act. And it tells us that subsection 1B in particular, I'll just take you back there, recording a private conversation to which you are a party. Subsection 1B does not apply to the use of a listening device if all of the principal parties to the conversation consent expressly or impliedly to the listening device being used. So we've already seen in the comments some Strata managers telling me, I think it's okay if everybody consents. That's always what I've required. I've had a Strata lawyer who says that's what's required. All of the principal parties to the conversation consent to the listening device being used, or the principal party to the conversation consents and the recording of the conversation is reasonably necessary for the protection of the lawful interests of that principal party. Just to be clear, the principal party is the person who's recording the conversation. So let's say that's you who wants to record the conversation. You are obviously going to consent because you want to record it. And if it's reasonably necessary for the protection of your lawful interests, then you are exempted or accepted from the offence. You are not committing an offence if you've consented to the recording and it is reasonably necessary for the protection of your lawful interests. That's what I'm going to focus on today. We're going to have a look at whether our Strata meetings are indeed private conversations? So, are they even covered by this legislation? And if you don't get the consent of others, which is this first exception to the offence up here in subsection 3A, if you don't get the consent, can you still record anyway? Because it's reasonably necessary for the protection of your lawful interests. And I found what I think is a pretty good case, which helps to explain and get us thinking a bit harder about some of these issues. Unfortunately, it is not a strata case, but it is a case to do with recording a meeting in a corporation's context. And for that reason, I think it's really instructive for us. I've stopped sharing my screen there, and I am going to let you know what the case is. I'm not going to share my screen while I'm talking about the case. I am going to share the relevant points and the learnings from that case with you here on the video, but we do have a link to the case. I'll tell you what it is, and then we will pop the link in. The case is Alliance Creighton Explorer Proprietary Limited and Quasar Resources Limited, a 2010 case from, surprisingly, the South Australian Supreme Court. We have a link for you. We'll pop it into the chat, and I'm going to go like this because the link has been having some trouble playing up for us as we were sound testing earlier today. I'll ask Rochelle to pop that in, and I do want to make sure that you can access that link because this is a case that I'm going to encourage you to go away and have a read of. It's super easy to read. It makes some incredibly important points, not just about recording meetings, but about recording generally, about protecting lawful interests, and also about the role of a chairperson at a meeting. I'm just watching that chat to see that link come in before I go too much further because in case anyone can't access that link, I just want to make sure we don't get distracted by that before we jump in to the examination of the case. I will scroll back up. James saying, can I record conversations so I capture accurate minutes at meetings? Great question, James. This case gives you, I think, an answer to that. We are seeing some legislation being shared by Debbie. Thank you for that. I will be able to come back to that, and I can see your long chat there, comment there, Debbie. Henry saying, hi, Amanda. This is the act that snared former Detective Chief Inspector Gary Juplin. Thanks for sharing that. Link seems to be working, I am being told here. What you will see here is not a link to the Ostley website or another website. That is not at all because I want to steal any glory from the very helpful resource that is Ostley. But I don't know if anyone else has experienced this lately. When you go and look at a case on Ostley and then you copy and paste the link, there's some caching issue with Ostley, and it doesn't allow you then to share the link. The link kind of becomes inaccessible. We've been having that trouble a little bit with Ostley at the moment. If anyone else is having that too, let me know. It's not just my tech issues. So what we've done is downloaded a PDF copy of the Alliance case and popped it on to our website. No opt-in or anything for that. Just click through and you will be able to have a copy of that case. Link works. Excellent. Thank you for that, David. All right. So you can access a copy of this case. Not expecting you to go and read it right now. Best thing you can do right now is have a listen here to the key points that I'm going to summarize for you. But in a quiet moment, glass of wine, cup of tea, definitely have a read of this one. It is about the conduct of representatives of two companies at various meetings of what they called their management committee. Now, this management committee was established by these two companies to essentially, I think, be in charge of making decisions about a joint venture arrangement between the companies. And the dispute that made it to the South Australian Supreme Court was about whether Alliance, the plaintiff, was permitted to tape record, is the wording used in the judgment. It's a 2010 decision, so maybe that's what it was happening. Tape record the management committee minutes and whether Quasar could prevent that recording. The first issue that the Supreme Court had to decide was whether the recording of these meetings was a breach of the South Australian legislation, which the sections that I've looked at in the judgment seem to be very similar to the sections that are in the New South Wales legislation. So court first had to see, all right, does this legislation apply, and has there been a breach of this listening devices legislation? And then there was a second issue about whether the chairperson could legally rule that there was to be no electronic recording of the meetings. So can a chairperson at a meeting, regardless of whether any surveillance devices or listening act devices legislation applies, can a chairperson just say, I am the chair, it is in my authority as chair, I can say no recording of this meeting? Does a chair have that power? And then thirdly, whether the committee itself could vote, and the majority of those present and voting at the meeting, could they decide to prohibit this kind of recording? So you might be hearing these three issues and think, yep, this is not a strata meeting in this case, but I can see how these same concepts and questions come up in the strata context. Does the Surveillance Devices Act apply to restrict or make an offence out of recording without consent? Can a chair say no recording allowed, and is that binding? And can the meeting vote to say, well, majority of us don't want this to be recorded, so it's not going to be recorded? I acknowledge straight up that this is a situation where Alliance was obviously, I think it was their lawyer who was present in the meeting, who was pressing that button on the tape recorder and saying, I want to record this meeting. It's not a secret recording. I am going to give you my thoughts about that other situation where no one else in the meeting or no one else in the conversation may know that you're recording. So these questions of, can the chair rule it to be prohibited? Can the meeting vote to prevent it? Those questions don't even come up if there's going to be a secret recording. I am going to get to that. But for our present purposes, and what this case is having a look at, is a situation where those present are aware that one party wants to record. And the issue went to the court purely on that question. It wasn't a question of, oh, we've got some evidence of something and we want to know if it's admissible or not, which is often how these recordings get challenged. This was actually a clear question before the court. Was this an offence under the South Australian listening devices legislation or not? All right. So first of all, the court had to consider, in determining whether or not this was an offence under the Act, the court had to consider whether this was a private conversation. And the New South Wales legislation uses the same terminology, a private conversation. I'm just going back to section 7. Yes, so it is those words used in section 7. A person must not knowingly install, use, or cause to be used or maintain a listening device to overhear, record, monitor, or listen to a private conversation to which the person is a party. So have we committed an offence under the Act? We need to work out whether we have recorded or attempted to record a private conversation. Now, this was a meeting, all right? This is a meeting of representatives of two corporate entities. And the South Australian court said, yes, this is private. It doesn't matter that it is a formal, official, properly convened meeting. It doesn't matter that there are minutes on record. It doesn't matter that someone else could have attended as a representative of these corporations. It doesn't matter that these representatives are going to be reporting back to their superiors or reporting back to their shareholders. Yes, this is private. And I think that question of, is this a private conversation, does come up in Strata as well. Imagine that you were at an AGM and the room is full of potentially 50 plus people if we're in a large building and we've got a good turnout. Are we still having private conversations in that context where the Surveillance Devices Act could apply? I say yes. I say yes. We are having a private conversation within the meaning of the New South Wales legislation. The South Australian legislation is a little bit different, at least back then when this case was decided. There was no definition of private conversation. What is a private conversation? So the judge goes through this exercise of working out when these two representatives are meeting and discussing the joint venture as part of the management committee that they've established. Is this a private conversation? Judge says yes. I think it is private. But the very interesting thing that the judge next decides he says it's private, but it's not a conversation. Remember, it has to be a private conversation. Judge says it's private. Doesn't matter that there's minutes, doesn't matter that the attendees are reporting back to their shareholders. But what happens in a meeting is not a conversation. A conversation is different to a communication, says the South Australian judge. Proceedings that take place at the meeting of the management committee, in this case, are meetings of an entirely different character to a private conversation. The judge in this case says that the parties are commercial, the meetings have a commercial character and commercial purpose. Each party to the joint venture is a body corporate, which acts through representatives or agents, and he uses the term body corporate as corporations, not as strata body corporates. They have a duty to report to the corporation. The exchanges at meetings don't have the required characteristics of a conversation. Meetings have formal written agendas upon which the parties exchange their positions, including the provision of reports to review. They reach decisions that will affect their legal rights and duties. A formal record is kept of the meeting, that's the minutes. There is formality about the meeting. And the judge therefore concludes that the communications at these meetings, although they're private, they are not conversations. So they can't be private conversations within the meaning of the South Australian legislation. Really interesting. And that's something that caused me to go over and have a look at the New South Wales legislation. And I thought, I wonder if this question came up in the context of a commercial strata scheme where you can say these are all commercial interests. What if it was a building management committee where we do have representatives from each strata plan coming together to meet? Is that the kind of situation where a meeting is not going to be considered a private conversation, but more of a communication in that more formal style? But I think the New South Wales legislation is different to the South Australian legislation in this respect because it actually defines the term private conversation. And it defines that term quite broadly. I might actually take you over and show you this definition of private conversation in the New South Wales legislation. So those of you who are just joining in, I'm looking at the Surveillance Devices Act, New South Wales, 2007. That is section 7. I'll go back to the table here in Ausley and have a look here at the definition, section 4 of private conversation. We're scrolling down to P for private. Private conversation. Now, the South Australian legislation didn't have this definition. So the judge in the Alliance case had to go and do the work of working out, is a meeting a private conversation? I'm not sure. Private conversation in the New South Wales legislation means any words spoken by one person to another person or to other persons in circumstances that may be reasonably taken to indicate that any of those persons desires the words to be listened to, only by themselves or some other person who has their consent. But it doesn't include a conversation made in any circumstances in which the parties to it ought reasonably expect that they might be overheard by someone else. So, look, tell me what you think. You may have a different view, but I do think that those who are attending strata meetings do reasonably believe that their conversations, that their communications that are happening in that meeting are private, that they only intend to be heard by those who are present at the meeting or by those who have the consent, express or implied, to hear those conversations or to read the minutes of that meeting. So people who may be inspecting the records of that meeting. I think, and the cases including this Alliance case and some of it that follows, make pretty clear that even if minutes of meetings are going to be distributed, even if someone's going to tell somebody else about what happened in a meeting, that doesn't mean that it's not private. And I don't think this question of what is a conversation, is it a communication, is it a conversation, that seemed to concern the judge in the South Australian case. I don't think that comes up in the New South Wales case because this definition is quite broad. It doesn't really um, suggest or create any difference between a communication and a conversation, in my view. So just be aware when you're reading the Alliance case that the result or the ultimately the result, as we'll get to, may well have been the same, but this discussion about whether the legislation applies, whether this was a private conversation, may be a different discussion in New South Wales and perhaps in other jurisdictions as well. I think our strata meetings are private conversations in New South Wales, and the Surveillance Devices Act is very likely to apply to those. I believe so that's Section 4, the Surveillance Devices Act. You can find that one by navigating through that table in Austlii, as I did there on the recording. So we have our judge in the South Australian Alliance case saying that a meeting is not private. It's not a private, a meeting is private, but it's not a private conversation because it's not a conversation, it's a communication. So there's no offence against the South Australian Act here. But just in case he's got it wrong, he does go on to consider the exceptions to the offence that are in the section anyway. And these exceptions are very similar to what I've shown you in our New South Wales legislation. So the judge considers, did Alliance have a lawful interest to protect by this recording of the management committee meetings? The judge goes and looks at other past relevant cases, and the important takeaway here is that each decision really does depend on its own facts. But helpfully, we can draw a few general rules, I think, from these cases, and these general rules are drawn out by the judge in the Alliance case. In most of the decisions, it is accepted that a mere desire to have a reliable record of a conversation is not enough to give you a lawful interest and permission to record the conversation. I think that might be an answer, James, to your question. You popped in earlier and said, can I record it so I can make accurate minutes? Short answer is no. A mere desire to have a reliable record of a conversation is not enough to give you a lawful interest. A desire to gain an advantage in civil proceedings would not ordinarily amount to a lawful interest, but each case has to be considered on its own facts. Some of the cases that are mentioned and that the judge has a look at, the conversation, the private conversation that's being put to the test, if you like, relates to a serious crime or the allegation of a serious crime. And in that case, a court is probably more likely to find that the recording of the conversation that relates to that crime or proves that crime or has some type of evidence in relation to that crime can be made in the protection of a person's lawful interest. So it really depends on what the conversation is about, what the specific scenario is. And if you do, as I know David Glover did, go and have a look at some of these cases, they're very often looking at cases of violence, domestic violence, child abuse, serious criminal activities where there is a listening device and recorded evidence of that activity. And the question is, should this be admitted? Simply trying to get an accurate record of a meeting is not sufficient, says the judge in the South Australian case, not sufficient to constitute a lawful interest. Making a recording in contemplation that it might be used if there is maybe some form of litigation down the track is also not a lawful interest. May be different if there is litigation on foot, if there is already a dispute happening, if there has been a dispute in the past about the accuracy of minutes, the accuracy of records of a meeting or a discussion, maybe then the recording will be allowed, it will be admissible, and you won't be breaching the act, or you won't have committed an offence if you have recorded it. Maybe then you will have a lawful interest. But I'm hoping that you can see how much of this really depends on the facts of the particular case. What happened in the case of Alliance? Well, maybe surprisingly, the South Australian court found that Alliance had a number of lawful interests it was protecting by recording, and therefore, if it had committed an offence, which, remember, the judge said, I don't think it has, because I don't think this is a conversation, a private conversation under the Act. But if I'm wrong, and if it is a private conversation, I think they can rely on the exemption, because the meetings of this management committee were operating within a commercial setting in which the commercial interests of the joint venturers were of central importance. The meetings were taking place pursuant to a couple of contracts for the purpose of carrying those agreements into effect. They were very formal, they were very essential to the terms of those agreements. Motions agreed or passed at the meetings, and other decisions that were reached at the meetings were affecting the rights and obligations of the parties. And so the judge said it is for the protection of the interests of both joint venturers that there is an accurate record kept of communications at the meetings. So I know you're all thinking, well, again, it kind of sounds like a strata meeting there. We're passing motions. It's a very formal process. We're protecting rights and obligations. It's sounding like we may have a lawful interest. I think it's going to depend on the particular strata plan. I think it's going to depend on the topic that is being discussed. Maybe in a commercial strata plan, maybe, as I said earlier, where you have representatives who are attending on behalf of their subsidiary bodies, attending a BMC meeting, or even a community association meeting where you just have those reps and they're having to report back. Maybe to protect lawful interests, their sound recording will be allowed. It really, really depends on the specific circumstance. So in the Alliance case, the judge has concluded that Alliance had a legitimate and lawful interest in the accurate recording of minutes of the management committee meetings, sufficient to afford it protection under the relevant section of the Act. I get a feeling when I read this case that maybe a different judge may have made a different decision. It is very much confined to the particular facts and this judge's particular interpretation of the facts. So this South Australian court has said not a private conversation is private, but a meeting is not a conversation. That, I think, is unique to South Australian law, at least at that time. Yes, this company had a lawful interest to protect. So even if the offence does apply, I think they were subject to the exemption. So everything is looking good for Alliance, you would think. Not so. Remember, I said there was a second issue to be considered in this case. The chair of the meeting had ruled that there should be no recording. There were a series of meetings, to give you a little bit more background, and Alliance wanted to record at each meeting. And at an earlier meeting, the chair had said, I am not going to allow these meetings to be recorded. That was noted in the minutes, or the way in which this group was recording the decisions of its meetings. And this question came up before the Supreme Court. Even if they're okay, even if Alliance is okay under the Surveillance Devices Act and they have this protection of having a lawful interest, where does the chair's decision stand? This is where this case gets very interesting from a strata perspective. And it's part of the reason why I've suggested you've got your PDF copy of it, go and have a read of it, because in unpacking this question and making a determination on this question, the judge says some very interesting things, helpful things, important things about the role of a chair. And it's not something I spent a lot of time on today because I was focusing purely on this question of the legality of the recording, but it's certainly a case I'm going to be going back to and looking at what this Supreme Court judge has said about the role of a chairperson. Ultimately, the court said that they consider the ruling that the chair made to say no recording allowed. That ruling was made in good faith, and it was to prevent it was made in good faith to prevent the meeting from being recorded, and that was within the scope of the chairperson's powers. So a chair, according to a South Australian Supreme Court judge, is allowed to say, in my capacity as chair, I control this meeting, I decide what the procedure is, and I'm not going to allow recording. I think the comment was posted here in the chat earlier. Someone said, I got some guidance from Strata lawyer Colin Grace. Sounds like it might have been along these lines. Make sure the chair says before the meeting, I'm not going to permit recording. Possible that Colin was aware of this alliance case, and that's where he's coming from. This Supreme Court judge says that that would be enough to prevent the recording, and alliance should not have recorded that meeting. In addition, the chair, just in case the chair didn't have the authority, the chair put it to the meeting. And the chair said, all right, let's take a vote on this. Who wants the meeting recorded? There was a party to this particular meeting that had a majority voting right, according to the contracts that everyone had signed. That party said, I don't want the meeting recorded. Alliance said, well, I want the meeting recorded, but they were in the minority. So the meeting itself decided, no, we don't want this meeting recorded. And the judge said, I agree that a properly convened meeting has the inherent power to regulate its own affairs. And that includes deciding whether or not the proceedings of the meeting can be recorded. Any disagreement between the participants should be resolved by a vote from those who are entitled to vote at the meetings. So the judge found that this management committee, in the absence of any other express permission in their contracts to record the meeting, they had the power to make a majority ruling on these matters, and that meant that they could prevent Alliance from making an electronic recording of the meeting. Now, I think remember this is a 2010 case. So a lot of the lawyers who have been talking about these provisions in the Surveillance Devices Act and talking about you must get consent if you want to record, perhaps even drafting motions, sample motions that owners can use to be able to seek that consent to record. I think this is all coming from having awareness and understanding of this Alliance case, this South Australian case. I'm not aware of a more recent or similar case, but this comes back to the power of the meeting to regulate its own affairs, the power of the chair to control the room, whether that's the electronic room these days or the physical room, and say, I'm not going to allow this recording. If that decision is made, then that recording is quite possibly not going to be admissible if you want to use that in court proceedings. If you do want to propose a motion to record what's going on at a Strata committee meeting, this is something that I have previously turned my mind to for owners who are asking for templates of such a motion. We do have these templates available to our members. Those who are inside the Your Strata Property online membership community will be aware of this. Inside our template library, our sample motion to record template is within our package of 10 sample motions that an owner may want to submit to a Strata meeting. We have a link for our members. This is a members only link that you'll be prompted to log in, and you'll be able to download that template pack, 10 sample motions, including a motion to record a meeting available in that pack. If you're not a member, but you want to get your hands on these 10 sample motions, including that motion to record, you can purchase this as a one-off, and we'll pop in there the link to purchase that pack if you are a non-member. So first link is the members link, free pack there for you. Second is the non-members link to purchase that pack if you want to have a look at a sample motion to record. So that's the Alliance case where the judge said Surveillance Devices Act, or I think it was the Listening Devices Act in South Australia, doesn't apply to this case because I don't think this is a private conversation. But in any event, this company, the representative of this company, was legally not able to record this meeting because the chair said no, and the chair is entitled to set their own rules. You didn't comply with the rules of that meeting. You have illegally recorded this meeting. Very interesting for us in that Strata context. But where does this leave us if we have an owner or we are an owner who wants to make a secret recording, doesn't want to tell the meeting, doesn't want to tell the chair that they are recording the meeting. So the chair can't make this decision. The meeting can't put the question to the vote. Maybe it's a conversation that's happening on the common property between a group of owners or between two owners, or a conversation with a building manager, or a conversation with a contractor that might be present in your own home that you're wanting to record. You don't seek their consent. On its face, that is a breach of the Surveillance Devices Act. I think it's a private conversation, as I've taken you over to the New South Wales legislation and said, in my view, the definition of private conversation is broad enough in New South Wales to cover meetings and absolutely cover those one-to-one or one-to-a-few conversations on the common property or on the lot property. So the Surveillance Devices Act would apply to prevent you from recording in the absence of consent. But do you have this lawful interest to be protected? And therefore, do you have that exemption under Section 7, subsection 3? And this is going to come up, I think, if the recording later comes to light and you want to use it in litigation, you want to use it as evidence of what really happened at the meeting or what really happened in that conversation, or you want to hopefully this never happens to anybody, but you need to defend yourself against a criminal prosecution so you don't get sent to jail for breaching the Surveillance Devices Act or have to pay that $10,000 fine. You're going to have to find a way, your lawyer will be telling you, to prove that your recording was reasonably necessary for the protection of your lawful interests. And I think we do get some good guidance on this from the Alliance case. Remember those summary statements that the judge was able to come up with after looking at some other relevant cases. A mere desire to have a reliable record of a conversation is not enough to give you a lawful interest. It is not enough to say, I want to take my own notes of this meeting. I don't write fast enough. I don't type fast enough. I want to be able to capture everything. I want to make sure that as a Strata manager, I make good minutes. So I'm not going to tell anyone, but I'm just going to record this meeting. That's not going to be good enough. Doesn't give you a lawful, you're not protecting your lawful interest in making that recording. If you just want to have great evidence for your NCAT proceedings, if you want to get that advantage, if you are trying to get some evidence of your neighbor saying something nasty or admitting to a breach of the act, that is ordinarily not going to be enough to give you a relevant lawful interest. When you're looking at gathering evidence in cases, it really matters, it seems, in the cases, what the dispute is about. If it is about abuse and violence, domestic violence, child abuse, criminal activity, those are the kind of cases where the court will say, look, didn't get consent, on its face, not legal, but this is exactly the situation where there is a lawful interest to protect. Those are the kinds of cases where the evidence is then admissible. I have yet to come across a case in the Strata context where evidence of a meeting, discussions on common property, recorded without consent, has been admitted into evidence as something that was reasonably necessary to protect a lawful interest. I think if you have a situation where there is already a dispute, where there is perhaps a pattern of behavior that meeting minutes are not recorded properly, or there is some blatant disregard of reality in keeping records, maybe that's the kind of situation where you may have a lawful interest in keeping the recording, or in making the recording you are protecting your lawful interest because of this pattern of behavior. But it's really hard to see how your action in recording would be approved, if you like, by the court if you're doing it in anticipation of a dispute, or you're doing it because you just think, I don't know if these minutes will come out correctly, so I'm going to make a record. If it's a part of a systemic recurring pattern of bad behavior and you want to be able to capture that to use in evidence for a dispute that has already come to light, not a dispute that might happen, but a dispute that's already on foot, then that could be, I want to be really clear, it could be There's no guarantees, and this is absolutely not legal advice. That could be a situation where a court might say, okay, I'm going to admit that evidence, but is always going to be up to the court to decide whether or not that's going to happen. Another case that may be helpful that I came across, this one, a New South Wales Supreme Court case, Kanjian Holdings Number 1 Proprietary Limited, and Kanjian New South Wales Supreme Court 839 from 2021. Link to that one coming to you here in the comments. This is an example where a recording was admitted into evidence under the exception in the Surveillance Devices Act in New South Wales. And it is an example of my point that it is in very serious situations where there has been some extreme, perhaps, allegations or behavior where this kind of evidence may be admitted. In this case, there were allegations of elder abuse and undue influence among siblings who were communicating with their elderly parents. And the Supreme Court of New South Wales in that case said that a desire for a reliable record of a contentious conversation to protect yourself against serious allegations, in this case, elder abuse, in the context of an ongoing and crystallized dispute gives rise to a lawful interest for the purpose of the Surveillance Devices Act. So there's an ongoing dispute. It's very clear what the dispute is about. There are very serious allegations that have been made. Recording yourself in a conversation that you know is going to be contentious, that may well be a situation where you are protecting your lawful interest, and may be a situation where the court would admit that evidence. So what everybody hates hearing from lawyers, the upshot is, it depends. It depends. But as David Glover pointed out to me in his notes that he sent to me, it is probably not correct to say that it is illegal to record meetings or conversations without the consent of the other people present. Yes, that is the starting point under the relevant legislation, but there are exceptions to that rule. And whether or not that exception applies is going to depend on the specific circumstances of the case. And it is incredibly hard, indeed dangerous, I'm going to say, for a lawyer to form hard and fast conclusions about what kinds of circumstances, in what kinds of circumstances that may apply. But certainly we can all think of some strata situations where there may be a lawful interest to be protected, and the best way to protect that lawful interest may well be to make a sound recording. Thank you, David, for raising this one. I'm not sure if you're still with us, but keen to hear your thoughts, other opinions, contrary views. I can see lots of comments here in the chat, and I am conscious of our time. I'm just going to scroll back up and see what I might be able to dive into. Dirta is here saying, thank you for covering this issue. No worries, Dirta. Chew is saying, I think as long as you use it as your own records, but not use it in any proceeding is okay. That is a very, very good point, Chew, and I'm glad that we could get to that. It is so true, and David pointed this out to me as well. Are the cops really going to come calling? Probably not. It depends on how you're then going to use that recording. Is anyone going to find out about it? Where are you going to send it? You're going to blast it. You're going to get all the email addresses from the Strata roll and blast it out to everyone. Are you going to use it in your NCAP proceedings? That's when these questions of, hey, was that legal? And hey, should that be admitted into evidence come up? So I absolutely take your point. I'm just going to scroll down to... I think I might have covered that. I've just got a note in the chat here to cover your question, Chu, because that was a good one. Oh, what about phone conversations? Yes. So we're talking about, so phone, there is, as far as I'm aware, no limitation on this, where this private conversation is happening. I believe the same would apply to a phone conversation. If you look at Section 7, it's a private conversation. If we're recording or monitoring a private conversation between two people or more than two people, and then a private conversation, there's no requirement that actually be in person. I'm just going back to my definition here. Any words spoken by one person to another person in circumstances where it's considered that it should be private. So yes, this would also apply to phone conversations. And thank you, team, for pointing out Chu's question there. That was a good one. Sean M saying that's interesting for using recordings for accurate minutes. Yeah, so I think that's a no-go for you as strata managers unless you do have that consent. Sean also saying minutes can be confirmed or amended at the following meeting of the same type. If they're inaccurate, it's pretty messy to get it corrected if there's not enough support. Yeah, absolutely been there. But I certainly, as I said, would not be suggesting any strata managers be recording meetings without consent. Bill and Ben saying from our recent committee agenda that the Strata Committee request any attendee at this meeting, including by Zoom, declare if they wish to make a sound or video recording of this meeting and refrain from doing so unless there is explicit consent of all parties present, and that all attendees acknowledge that failure to comply may result in prosecution. Very interesting, Bill and Ben. So that's you trying to, or your committee rather, trying to acknowledge that some people may not be announcing their intention to record or putting forward a motion seeking permission to record. You're trying to get on the front foot there. So anyone who may be secretly recording may be prevented from using that, relying on that in the future. Interesting to see how that would play out. And this is the thing. I did go and have a quick look. I can't find any strata cases. And I confess, I'm going to go back to Debbie's comments there about Queensland being a bit different, but I confess I am only looking at the New South Wales legislation, aside from this Alliance case, for any recent Strata Surveillance Devices Act cases. Jane, I think that's half a comment there. I'll leave that one with you there, Jane. Dirta saying, what about being regularly bullied, abused at meetings? So perhaps, Dirta, that's the kind of situation where I talked about, there's a pattern of behavior here. The trouble is, or the question, I suppose, will be, is there already a dispute about this? Are you already, if it was you who was suffering from the bad behavior and the bullying, are you already taking steps to remedy that, to resolve that, to have committee members removed from their position, for example, because of their bad behavior? Because if that bad behavior is happening and you may commence proceedings to have a committee member removed, for example, not what I'm suggesting, but for example, it may be that the committee members will turn around and say, yeah, we did do that. We did behave like that. We did. I mean, it may not end up being an issue that's in dispute. And that's the legal lens that is placed over this. We need evidence to prove facts that are in dispute. If a fact is agreed, it's not in dispute, we don't need evidence of it. Everybody's happy. It's real. It's true, almost. This is why we're hearing the cases say, unless there's a live dispute, unless the issues have crystallized, unless there's something already, there's a proceedings on foot, there is probably not going to be a lawful interest to protect. Might be different if you've started your proceedings, committee member has said, no, absolutely don't do that. That's not what happened. This is what happened. And then recording the next meeting where you think it very likely that that behavior is going to happen again. And that would then be important evidence for the court or the tribunal to be aware of. That could be maybe a situation where that kind of evidence would be said to be protecting your lawful interest. But it's such a fine line, a really fine line. So I'm very loath to suggest to anybody that they start recording their meetings without that consent. Henry saying there's a reason why police caution you prior to an interview. Yes. Bill and Ben saying tough to know if one has a lawful interest when often the lawful interest determination comes after the recording occurs, as many cases demonstrate. Absolutely. Great way to encapsulate that, Bill and Ben. That is exactly how it works and why it's so difficult. Dirta saying, what about a text conversation? So we're only talking about spoken words. When we're talking about private conversations for the purposes of listening devices, it's all about spoken words and listening devices. If you've got texts, then that's evidence. That is hard evidence. That kind of evidence would usually be, depending what it's about, would usually be admissible. No, I'm going to stop there. I'm going to stop there, right? Put myself in a dangerous territory there. Bill and Ben saying, breach the Surveillance Devices Act and you are likely to get a small fine and a Section 10 if it's at a Strata event. That's possibly the case. Very interesting, says Sean. Oh, thank you. Have a good weekend, everyone. Thank you, Sean. I am going to channel you into our closing and goodbye. Thank you all for tuning in here today. I knew that was a big topic to cover. I thought at about 3 p.m. I may have bitten off more than I could chew, but I hope that some of that is helpful to some of you. If you found it interesting, if you think it will be helpful to your Strata manager, to your neighbor, to your fellow committee members, please do hit that share button on this video. You can share it across Facebook, you can share it across LinkedIn, hit the like button, give me a little love heart. That helps us get this information out to more people in Strata who need to know about it. I do think that grabbing a copy of that Alliance case and the other case that we linked to here today as well, that will in turn refer you to some other cases if you're particularly interested in this topic and reading more, as David Glover very helpfully did and wrote to me about this and made the very good suggestion that we do this deep dive here on live today. If you have further comments, further thoughts on this one, I would love to hear them. But for now, I'm going to let you out into your weekend. I hope you have a wonderfully relaxing, rejuvenating weekend. And I will catch up with you all next week. Bye for now.